out. Okay, let me start again. An incapacitated person means a person, a minor or an adult individual who, because of physical or mental condition, is substantially unable to provide food, clothing, or shelter for himself or herself, to care for the individual's own physical health, or to manage the individual's own financial affairs. I'm wondering what the legal definition is, and we can start with the Kenyan side. Leah, just go ahead. What does being incapacitated means on the legal end, and then yeah, we can go with the definition on the US side.
So interestingly, what our law says is that it defines who is a person suffering from a mental disorder, because from our, and this is found under the Mental Health Act. So usually this conversation arises when there's a mental health disorder. And so the Mental Health Act says who gives the definition of what it means to be a person having a mental disorder. And what it says is that a person suffering from a mental disorder means a person who has been found to be so suffering under the Mental Health Act, and includes a person diagnosed as a psychopathic person with mental illness, and a person suffering from mental impairment due to alcohol or substance abuse. That's what the law says. So the definition is based on the, I guess, on a diagnosis by a doctor, so that even if you go to court, the person, you have to have some certificate, a medical certificate from a doctor confirming that you have this mental incapacity, or that you're suffering from a mental disorder, or that you may be having a physical problem that has incapacitated your mental capacities.
So, without the doctor's diagnosis, it doesn't fly in court? Oh,
no.
Okay.
And in fact, what I'm finding now with courts, interestingly, is insisting on a specialist. You know how our health systems, we are in the third world, so we have struggles. So it's possible, you will go to your GP, your nearest medical practitioner. In fact, I keep saying that all my life, early before the 90s, I grew up seeing, we saw doctors. Then the 90s happened, structural adjustment policies, the World Bank said cut off medical services were privatized. And so then now, for the rest, until my 20s, I think my doctor in my village was called Dr. Juma, and he was not a doctor. And this is the situation for many Kenyans, is that the person who is handling your health issue may not be a doctor, leave alone a specialist. And so what I'm seeing now courts demanding is actually something from a specialist, either from a psychiatrist, or I've also seen if the issue is a brain, if you're having a problem with your brain that may not be maybe psychiatric. What's the other one called?
Like if you have a tumor, you have diabetes that's affected, metabolic disorder that's affecting your brain. Yeah, exactly.
Now, because under the Mental Health Act, it's the High Court that has the power to deal with your issues. I'm seeing courts saying, don't just bring me something from a clinical officer, don't just bring in something from even a GP. They're saying, bring me from a specialist. I want to see a certificate confirming that the issue is a mental health issue, and that this person then can be certified under the Mental Health Act to have a mental health incapacity.
Okay, so James, I have to Kenyanize you a bit. In Kenya, anyone who works in a hospital is called daktari, meaning doctor. So anyone, from even my own parents who were cleaners in hospitals, were viewed as doctors. So they could administer stuff to you, and they're called doctors. And then there are different cadres. There's like a sub level that almost equivalent to a PA here. It's called a clinical officer. Those ones are also viewed as daktaris. And if I stand toe to toe with a male cleaner, me with my credentials, I will not be seen as a doctor because of my gender also. So I like that the High Court has gone ahead and insisted on specialists. So James, what's the same question? Yeah, what do we have like a definition here in the States? And yeah, just the same way Leah did.
Sure. So it's very interesting to me how just in these first few minutes, we have gotten into the heart of the issues around elder care. And I think actually your flyer also very maybe coincidentally and quite interestingly also went right to the heart of the issues with the first word you used in the title, planning. Because dealing with elder care issues and cognitive challenges is all about planning, because once the problems arise, often if one has not planned, one is already behind on how to deal with the issues. And this has most to do with the fact of mental incapacitation and how it is others come to intervene. And I think your definition, Posa, of incapacity from the dictionary is not at all unlike the definition in use legally, that it is the very things described in the definition, the inability to deal with all the ordinary things of life that define incapacity, not only in the dictionary and the medical context, but also in the legal context. I think it's also very interesting, the challenges or the situation you described with regard to Kenya, because what Leah described about proof in court also gets to the heart of the issue. When are we actually going to say someone has crossed the line and needs help, and that help needs to be sanctioned by law? You can't take just any and everybody's word that someone has passed that point. You need to create a high enough hurdle so that we are not depriving someone of their autonomy and their rights merely because just anybody says so. But I'd like to go just a slightly different direction than Leah did about getting to that point, because there's another way to get to incapacity and the help of others other than by way of a challenge in court. And I think it's maybe the most important route to travel en route to defining incapacity and then doing something about it. You don't have to go to court to prove someone has reached the point of incapacity if that person, him or herself, acknowledges that they've reached the point where they need help. Because then they're in a position legally to ask for that help and to grant legal authority to other people to act on their behalf. And that's always the easier situation. If you have to fight about it, if you have to prove that your older relative no longer has sufficient capacity, there will be ugliness because different people will have a different view. It will require proof. And often the people around the person who is declining will themselves be fighting with each other, either about the fact of incapacity or who should have the authority to act in that person's place. what happens most times, fortunately, I think in many countries and in the United States, is that this point of incapacity, that not being able to take the medication, the not remembering whether you took the medication or not, you're going outside for a walk and forgetting where you are. Those are all features of incapacity where the rubber hits the road. And the easiest way to get to it practically and legally is when the old relative says, yes, I recognize I've reached that point and I need your help.
And in your experience, is that like if you're giving percentages, what the people who have insights to ask for help, are they the majority or the minority? James.
That's a good question. I don't know. I know this, that there is a problematic minority who resist. And my guess is Leah sees the same thing.
Leah, what are the numbers like?
I think, you know, the interesting thing is, even if you look at our Mental Health Act, there is the Mental Health Act talks about voluntarily submitting yourself for mental health care, and then there is also involuntary, and the law therefore recognizes that sometimes people will not voluntarily admit, or, you know, and there's a lot of stigma around mental health, and it may mainly be cultural. So I have very many people, maybe once, a few times I've been asked by somebody what they can do because, you know, their parent or their sibling is unable to manage their affairs. And but as long as a doctor has not said you're incapable, and the person, and if the person is not willing to make the necessary plans to have that sorted, then you are stuck. I did once, a woman came to me with her sisters, with her late sister's husband, and she felt that her late sister's husband was mismanaging their wealth that her sister had left behind. And she really wanted him to take action and to take steps, and wanted to be appointed his guardian. And she said, you know, so-and-so is conning you, taking advantage of you and taking your money. You've had these transactions where I feel that these were unwise. And he said clearly that, you know, he's able to fight his own battles. He's able to fight his own battles, and therefore she could not intervene. She should not actually, you know, he basically was calling her a busybody. But there will be some instances where somebody is saying that, you know, I'm okay. But there will be instances where people say, where it's so obvious that that help needs to be sought. But let me say that from the idea of planning, I think one of the things that people need to do is to develop relationships and to have people you trust. So that, for example, simple things like who can run your card, somebody trustworthy, maybe have one or two people who can run your card at the ATM, because that's usually the problem. You get sick, you're in hospital, and you can't, nobody is able to access your accounts, your medical bills are piling up, and nobody is able to pay your medical bills because nobody can run your card. But the legal problem we run into in Kenya from that aspect of planning is because what we usually do when we are fine to plan is to say, give somebody a power of attorney. So you donate a power of attorney for somebody to act for you. But the thing with our law and the way we view powers of attorney is that you can only give a power of attorney when you're fine. So you can't start to give a power of attorney when you're already having the mental incapacity, because at that point, the question is whether you have the capacity to even give that power of attorney, number one. And then number two, when your attorney can only do what you're able to do. So your attorney cannot do what you're not able to do. So when you donate a power of attorney, at the point that you're certified or that you are certified to have the incapacity, then your attorney no longer has the power to do what you could have done. And most times, actually, the practice in Kenya is to do a power of attorney and for people to continue to act on the basis of that power of attorney. But if a challenge arises, then a strict reading of the law would be to say that power of attorney is no longer in force, which means the best thing to do for planning purposes is to have somebody trustworthy who can run your affairs, and that you can give the power to run your affairs together with you, and then that they can take over or do what you need to do or what needs to be done during the time that you are incapable. Because with these things also it's ebb and flow. You're fine at some points, and then at some points you're not fine. You're unwell, and then maybe you get better. But I also wanted to point out, James, that it's not always a fight, and it's not usually a fight. It's not acrimonious proceedings all the time. It's not one person saying this, the person is unwell and the other person saying the other is unwell. And I'm really looking forward to learning, because we haven't developed as an elder law in Kenya. Maybe, I think for various reasons. I think some good, some bad. I think our family ties have been such that somebody will take care of you when you're unwell, and that your community will stand in for you. And because we always owned things communally, at least more recently than the West, so you didn't have really what is yours individually, that only you can control, that belongs only to you. That concept of individual ownership, I think, is less than a decade and a half old in our communities. But I also wonder if it is because maybe our mortality rate is low. Maybe we don't grow so old because our health systems may not be as developed. But now with improved healthcare and with technology not only being developed but reaching us, people are now living longer. So it is just, actually, we now have a bill called the geriatric bill, which has not become law. And Posa, you have to correct me. Is it geriatric or geriatric? English. Thank you.
Ger for geriath and ger for geriatric.
Yeah, geriatric. The geriatric bill. I grew up reading G for gate. So we now have a bill, but it's just a bill. It's the first time I heard about it last week. It's new. We don't have a body of elder law. We've not got there. So all our actions are basically based on the Mental Health Act. So I'm so keen to hear what's going on in other countries, because I know other countries are, especially the West, because of the history, they're a bit ahead of us on that. And it's going to be interesting for this area of law to open up. And so, but the point I'm making is that it's not usually a fight. It's just you've got to that place where somebody has to step in. And under our law, because we took it in from the colonialists, it's very, whatever whatever you individually now own is yours. Nobody can walk to the bank and withdraw money for you unless you yourself do it or somebody that's authorized by the court. And that's why we now have to go to court, so that the court, it's not usually an acrimonious adversarial process unless, now members of the family can't agree. Usually it's just that the way the law is set up, and that's why I'm interested in hearing what's happening in other countries and what we can learn from them. It's just that the way the law is set up is that at the point that you're incapable, then only the court can step in. If you can't do it for yourself, somebody else can only do it by court order in a process that is not usually acrimonious or adversarial.
It's very interesting. Elder law is also developing slowly in the United States for a variety of reasons, some quite like Kenya. For one, the United States has this feature, this structure of law, federalism, where the law actually often develops not nationally, but in each of the 50 states individually. And the federal government is often reluctant under our system and called on to be reluctant to just pronounce law for the whole country. The idea is it should develop in the different states and that the different states might try different things, and altogether over the years, common practices will develop and different states will borrow from each other the best features of an area of law, including elder law. That's one impediment, but that applies generally. More specifically to elder law, some of the same kinds of things in the evolution of society have caused the growth to be slow. One is that families in earlier times were much more bound together and able to act on behalf of a senior relative. That impacted both how property was owned and the level of intimacy and the knowledge of the condition of a person. And what we've seen over the last few decades is family matters less. Households are much more 2.5 people instead of 5 or 6. So all of that infrastructure around protection has eroded over time. In addition, it's a population thing. People in the United States are a lot older than they used to be. And that largely has to do with the aging of the so-called baby boomer population. In the years following World War II, 1945 to about 1960, the population grew dramatically, and then it grew much less dramatically. And the people who were born in that time period are now becoming the seniors. Going back a little, if you take the sweep of people born between 1940, the beginning of World War II for the United States, and 1960, that whole 20-year period, that's the big population, and now they're the ones that are getting old. Prior to that happening, there was less impetus for the development of elder care law. Now there is, and all the things we're talking about come into play. Just to touch on two other things Leah mentioned and the interesting and unfortunate intersection of things in this area. One of the things Leah was speaking to was the problem of undue influence. Someone being present and trying to intervene, maybe not positively in someone's decision-making. That would be a bad thing anyway, but the whole problem with incapacity is that it makes a person all the more vulnerable to undue influence. So just at the time that is likely to do damage to a person's affairs is when a person becomes most vulnerable to it because they're older, less sharp mentally, and less able to discern something very important. And this is something Leah mentioned, which I think is maybe the most important word in this whole discussion. Who do you trust? Trust is key. And when you lose your ability to discern, I mean, how do any of us know whom we should be trusting? I mean, that's a hard thing in life anyway. As your capacity diminishes, it becomes all the harder to figure out the right people to trust. And there are consequences for not knowing the right people to trust, because then you can be taken advantage of. Just one other legal point, and I can speak to this one not only from the standpoint of the law in a neutral way, but also from my own personal experience. And again, I think Leia's gone right to the heart of the discussion, the way the issues play out. My parents, both of them are deceased now. My mother died a little over a year ago, and my father about 11 years ago. Early on, and while they still had capacity, they prepared a broad power of attorney for me. And when they did that, they also spoke with my brother and sister, my only siblings, and they said, my brother and sister are both in the medical field. They said, James is the lawyer in the family. I think we all trust him to act on our behalf if there is a problem, and we're not going to wait until we don't have capacity. Because we trust him, we'll grant him full and complete authority to act on our behalf. So it's done in advance. And then they, in addition to trusting me, they sort of trusted our collaboration. And this goes to a key issue Leia mentioned. So can you have both people acting at the same time? The grantor of the power and the recipient of the power. That's problematic, because if the person who granted the power still has power, why do they need you? Which things do they do, and which things does the person receiving the power do? You don't want to be fighting about that, because one may end up with all the power and another one not any power. My parents' view on that was that as long as they had sufficient power to act on their behalf, they would, and they expected that I would ignore the power of attorney entirely. And that at some point jointly we would reach the place where we would agree that I would be acting on their behalf and they would defer to that. It worked. But that's a hard thing. That's one of those things you just have to pray works out well, because it doesn't always in the manner Leia was describing. It is, however, generally safer, at least to have the power of attorney in place, because the alternative is worse. No power of attorney, and then when you reach that point, no one can act on your behalf, and it can be a disaster.
Okay, we'll need to go, oh gosh. Okay, we'll need to go to definition. So this whole power of attorney, trust, wills, and then we'll go through the planning process. But since Bugo is on top of her tree, she can chime in anytime. Bugo, are you awake, alert, and you're not cooking onions?
I am here. Today, my nephew is graduating, so I'm actually just being asked for the cake. But I am here. I can hear you. Thank you for having me. Yeah, I'll chime in when you need me to.
Okay, no, but can you just tell us the process? Okay, for those who don't know, Bugo's mother, Jerioth, Precious Jerioth, is has dementia. She's diagnosed and she's under care. And Bugo went through the whole. I mean, the family went through the legal process, and I just want her to just give us like a, you know, like an elevator speech form summary. English is my 20th language, right? Just tell us how you guys went about this and why you decided to involve the law.
Okay. Yes. So my mother was diagnosed with dementia, Alzheimer's dementia, in 2016. I believe it was 2016 or 2015. 2015. Yes. So what had happened was, like I said, she was behaving. I said, I think in the other meeting, she was behaving really strange. She was, of course, forgetting a lot. She was making very unusual financial decisions, which got me worried. And so I tried to, being the last born, I didn't want to be the one to have to take that responsibility all on my own, because of course with family, everybody will be suspicious. So I tried to loop in my sisters and brothers. And unfortunately, by that time, my mom was already being taken advantage of by two of my siblings, and being made to sign documents, sign property over. So at the point I even think one of the documents that she signed, signing away one of her properties, was done after the diagnosis. But this particular sibling was going around telling everybody, including my mother, that your daughter is going around telling everybody you're crazy. And of course, my mom would get defensive. Of course, she kind of knew something was going on, but every time I'd tell her we need to go see the doctor, she'd say, oh no, I'm not there yet. I'm not, she'd get incontinent, and I'm like, Mom, we can now talk about adult diapers. And she's like, no, we're not going to talk about that. So even she was processing it for herself. But what made it difficult was my siblings. Everybody starts with denial. So of course, initially it was like, yeah, she's a little kind of off, but it's really not that bad. But she has this friend, her very good friend, who they'd spend a lot of time with. And her friend just kept telling me, your mom is not okay. You need to do something. Your mom's not okay. And in fact, one of the transactions that my mom did after her diagnosis, she was with that friend, and that friend had been coerced into going to be a witness to the signature. And when she read the documents, she refused to sign and called me right away. She said, your mother has just signed over her land to your sister, and I've refused to sign. And on that trip, they were driven by my brother. And my brother knew this was going on. He was part of it. And so he said, well, if she's not going to sign, I'm going to sign it. And they signed it, and that was the end. And so at this point, my mother is penniless and she is assetless. She had signed over everything to her children, and two particular ones, not the rest of us. So that, after a while, my sister started seeing what I was talking about. She would get into very, very violent, not violent, yeah, but verbally violent altercations with her minders. And I witnessed one where I thought, I understand the minder's point of view, but also my mom was really rough, So then, yeah, my sisters are lawyers. I talked to them and they saw my point, and they were like, okay, fine, then just find somebody. I called Leah. Leah told me that, yes, you can get, what is it called? Custody. Is that what it's called, Leah?
Guardianship.
Guardianship. There you go.
Yeah. So we got appointment of guardian and managers of her property, of her affairs.
Okay, Bugor needs to go back to her tree. James,
so we got guardianship for my mom, handled all her legal matters. And it was kind of too late. Can you hear me?
Yeah, you went off a bit, but yeah, just go on.
No, so I was saying, by the time we got the guardianship with Leah, it was already too late. She had signed over everything, and yeah, so now we take care of her. And funny enough, even the children who she signed over all these things to are not particularly involved in her care. But yeah, so that's what happened. So like was said earlier, they are so vulnerable. And a lot of times they know something is off, and it's hard for them to explain it. It's harder for them, and at the particular time, the ball is already rolling and they don't know how to stop it. So they just go with it, So I kind of felt like that's what would happen with my mom, because in one of the instances where she withdrew some money, and I found she kept telling me she had no idea about that account, which was one of my dad's account, and we were trying to do my dad's administration of his estate. And I kept asking her, Mommy, where does this money go? And where does this money? And she'd always tell me she doesn't know. She has no idea. And so one day, as I'm cleaning her room, I find a withdrawal slip. And I'm like, Mom, you said you don't know where these accounts are, but you're withdrawing. She said, oh, that wasn't me. I said, what do you mean it wasn't you? She said, yeah, it wasn't me. It was, so she just acted so strange. And eventually she said, okay, it was your sister. It wasn't me. So it was not a small amount. It was like 250,000 shillings. I said, what happened with 250,000 shillings? And she says, Well, she took most of it. She gave me 10,000 of it. And for her to admit that, you know, I think she was like, okay, something went wrong there and let me come clean now, you know, whatever. But she couldn't explain what had happened, you know. So I'm glad we eventually got a hold of it. But by that time, I mean, they even claimed her unclaimed assets. You know, we have the unclaimed assets, something, right? Whatever it's called. I mean, they went in there and cleaned it out. So she was completely, everything was gone by the time we got guardianship. But yeah, that's in a nutshell what happened.
Okay, so we need to go to definitions, but let me just address Mwakesha before the conversation we did on dementia was 2 hours long. So for dementia patients, some of them get what we call lucid moments, but like Leah said, it's ebb and flow. You don't know when they'll get it and how long it will last for them to get, you know, like the way Jerrioth had like a moment, she was like, yeah, there's something off. That happens, but we don't know. It's very shaky. You never know when it will happen. Colette, I think we're going to address the property issue when we get the definitions and how to properly do these things so that we look like people of watu wamesoma. James, you just have to learn Swahili eventually. Okay, so let's go, because I know that the terms differ between, I mean, like attorney is more, I'm just pointing because this is where James is on my screen. Attorney is more US, lawyer is more Kenya. So let's just go through the definitions and then the proper way, like if you were to advise me and my few coins on how to plan for my children in case Posa's brain stops working. Yeah, let's just go through that with all the definitions. Leah will start with you, and then James, you will take over where the Commonwealth stops.
Okay.
Okay.
So I think we've already talked about incapacity. Maybe, and power of attorney, it's very interesting because in the US, an attorney is a lawyer. And then, you know, you Americans have, you know, built this empire. So I see my students because a power of attorney in the sense of our law is nothing to do with a lawyer. It's just what you donate you donate your legal authority to somebody else, or your powers, and you say so and so can do this and that for me. That's called a power of attorney. You can have a general power of attorney or a specific power of attorney. Ordinarily, we do powers of attorney because, for example, you're purchasing a property and you're abroad. You need somebody to sign the documents for you. And not so much purchasing now, not so much because you can send documents abroad and they're signed under notary. But sometimes you will sign a document for somebody to be able to do the things for you. And we call that a power of attorney. And I see my students having a hard time because when I ask about power of attorney, they go into a lawyer because, you know, they've been through law school, but the US, the US has stolen our minds. And so I see my students struggling with, you know, a power of attorney, and then then the confusion there. But basically, a power of attorney is a document that you make where you give somebody else to do the power to do what you could yourself do. So for example, to withdraw money from an account, to transact on your behalf in a transaction, even transfer of property or purchase of property, to get that person to act for you. The best example that I usually give is for banks, for example. If you think about the directors of banks never sign the daily documents that banks have to sign. So there are specific officers in the bank that are mandated to sign on behalf of the bigger institution, the bank, and they have powers of attorney. So that's what a power of attorney is. It's that document that is filed, that you prepare and you give somebody else the power to act for you.
So if I may interject, to criticize American law, certainly, but lawyers in general and our choice of terminology. Power of attorney is as bad and inaccurate a name for a thing as one could possibly think of, for exactly the reason Leah is saying. It has nothing to do with attorneys. Why is it called a power of attorney? What it ought to be called is the power of the person. Power of incapacitated person is really what it should be called, because one, it's not the power of the person, attorney or anyone else originally, and it requires no attorney at all. It is the bestowal of the power of the person who bestows it to anybody on the planet to act on their behalf, including, for example, as Leah is pointing out, at a bank or at any number of transactions, including property and the other stuff that really comes into dispute here.
Leah, go
Yeah,
on.
yeah, yes, yeah. So yeah, it's it becomes very confusing, as James says. Then another thing to consider is maybe guardianship. So what happens in Kenya if you can no longer handle your affairs is the Mental Health Act provides for you to approach the High Court, and the High Court will appoint somebody to be your guardian to take care of your affairs, but also the manager of your property. And that person then is given the power to sign off on bank accounts or to do things related to your property. But I'll tell you that courts are very, I don't know, the word to say is careful. They don't give these orders freely because they do not want to give people a free license to disadvantage people who are incapacitated. And so it is usually power, for example, to manage a certain bank account. And you have to ask specifically which bank account if you're going to be appointed as a manager. And actually, there's also a requirement for you to give accounts of what you have done in every 6 months in the law. That's in the law. I don't see it enforced on a daily basis, but there is a requirement to go back to court and tell the court that in the last 6 months, these are the transactions I've carried out on when you have been appointed as manager. And also it's supposed to be, the manager is supposed to only access the property for purposes of taking care of bills, taking care of debts, taking care of bills, providing for dependents of the incapacitated person. So when people talk about, like, the question is property is involved, all members have their own views of how the aged apportioned their wealth. That's what the courts are afraid of. The idea that when I give you this, you will go and take over, sell the property, share it, and the person is alive. And that our law does not countenance. So that's why courts are careful. So when you're appointed as manager, it's not to take over and distribute the property of the person who is incapacitated. It's to be able to pay their bills, so if you're selling, actually you would need to come back to court and ask the court for permission to sell. You're just supposed to manage, not dispose of. And so it would be for purposes of paying debts, taking care of their needs, and taking care of their dependents. So that's a guardian. That's a manager of the property. Then there is also, the guardian is the person who's supposed to be taking care of them, making decisions for them. And so the guardian would say, let's withdraw this money. And then the manager goes to the bank and withdraws. And many times it will be the same person or one or two people. So those are the definitions. I don't know if there are other definitions that you want us to go into.
Oh, because I followed the Britney Spears saga, I really want to know what a conservative that thing is. That word is that it's a James question?
It's a James question. Yeah, it's a James definition. I think we have it in the sense of the guardian and manager of somebody's estate, because I think it was following Britney's meltdown in 2008 or 2009. I think she was struggling, and that's why they appointed. It's sort of the same thing, but maybe James, you can point out what exactly that was. But my understanding of it as I followed it was that it's the same.
It is essentially the same kind of thing, certainly the same principles. one challenge with terminology in the law, and we see this again, especially in the United States, where 50 different states are developing law and using different terminology. And some of the terminology challenge has to do with a fundamental thing with regard to these kinds of legal processes. They tend to be in place for sort of three categories of people. The young, who need someone to see to their affairs. And sometimes that young person stays young until they're in their 30s, like Britney Spears, or the old who no longer are able to quite handle their affairs. And then a category of people where age is not really the aspect under consideration, but just mental health challenges where the incapacity also develops. And two issues come to mind as we're discussing the terminology. And again, Leah spoke to this. If you have more than one person who is in a role as guardian or manager or conservator or trustee, then how do you delineate the duties so that there is not conflict between them for managing the person's affairs? And that's the kind of thing that courts will pronounce on when they appoint people, but it sometimes can be problematic. The easier solution is that you have one person who has all the authority to act on behalf of a person, because then that conflict doesn't arise. And again, as Leah was saying, the role is that of a fiduciary on the behalf of a living person, which is very different than the kind of fiduciary responsibility for a trustee after
what's fiduciary? Come on, Jim.
Yeah,
What is
yes.
fiduciary?
My following words will backtrack to the definition. I did not intend to leave you in the dark. So first, the two kinds of fiduciaries to distinguish that, and then what the fiduciary is in each instance. And why I'm using the term fiduciary rather than conservator or guardian or manager goes to not so much the task, but the fundamental approach to the task, which Leah alluded to. The responsibility is that the person act on behalf of the person, that they owe that person a duty of loyalty to act in that person's best interest and not in the best interest of themselves or anyone else. That is the essence of the fiduciary. And the fiduciary acting on behalf of the living person is not there to say, okay, you no longer have full capacity. Let's pretend as though you're dead and give out your stuff. That's not fiduciary action, because that can rarely, if ever, be in the best interest of the person for whom one is the fiduciary. If the person is living, then the best actions on their behalf involve optimizing the things they own for the best possible living situation for that person. Because the fact that they have less capacity doesn't mean that they're no longer entitled to live the best possible life they can, given what their resources are. And regardless of the term used to describe the person's role, conservator, guardian, trustee, manager, courts are very insistent that the person in that role recognize that they are in a fiduciary capacity. And again, this goes to what Leah was saying. The submission of records every 6 months or so has primarily one purpose, so that a court can examine, a court or someone can examine that in fact, the person who is acting on behalf of the person is doing it in the person's best interest and not in anybody else's best interest. I do want to go back to just one other thing that let's see, Leah spoke to this a bit, pardon me, just moving something out of my screen, but Bugo also spoke to this, this whole thing about denial. Denial is a big thing. Denial is a thing. And it's an understandable thing and a very human thing. People don't want to acknowledge that they need somebody to act in their best interest other than themselves. And because to acknowledge that is to acknowledge that you're in a place that you have typically many fewer years to live than you have lived before. That's weighty stuff. And the people around that person also, if they love them, are reluctant to make that acknowledgement as well. And then you have other people, unfortunately, who sometimes have no hesitation to acknowledge a person's condition because they want to take advantage of it, all of which goes back to this idea that courts are in fact trying always to be careful and to examine that whatever happens, the appointed person, again, guardian, trustee, conservator, whichever, is acting in the best interest of the person, the fiduciary.
Leah, do you want to add anything else? And then I would also want you guys to touch on trusts, wills. Clearly, I'm in a class here because I have no clue what these things are. What's the difference between the trust and wills? And then, like, if we were to have a template on what people should do in because we become more individualistic, how do we bulletproof ourselves in case of we decline? We decline in and get incapacitated in one way or the other.
All right. Allow me to say that one of the reasons, for example, in Kenya, and this is on the issue of trust, one of the reasons in Kenya that we usually will appoint 2 guardians or 2 people is because of that idea that one person will check the other. So in the family, rather than giving the power to just one person, is that, you know, if there are 2, they would have to, what can I say? They would have to connive to go against their fiduciary responsibilities. I think it's just the idea that if there's 2 of them, there's less likely to be an abuse of the power that that the court has given them. But, you know, when you mention trust, I think that is such an interesting thing that you say, because of for planning purposes, it would actually be a good idea to actually put the property, to put properties, for example, or create a trust situation where somebody, and if you do that in advance, then at the point that you are incapacitated, the person will just take over. And that, I think, would overcome the hurdle that I was talking about earlier, about in Kenya, the power of attorney ceases. You can use it, it's good to have it, it's better than having nothing. But once you have been certified as incapable, then there is a problem with that power of attorney, and whether you still, the person holding the power of attorney still has the power, because you are no longer able to you don't have, the attorney should be able to do what it is that you're able to do. So if you're no longer able to do it, They shouldn't have the power to do it for you. And it's a technical question. I've had arguments with many people. I was in a situation where I had a big argument with my client, and she was very unhappy that I was suggesting that the power of attorney was no longer in force. But then what happened is that there was a suit in court on something else, and the person who had donated the power of attorney was sued. And so when then the attorney now had to defend, but the question was, if they are incapable, can you defend them, or should you be getting a guardianship order? And it eventually ended up needing to get the guardianship order for purposes of the court process. But on the point of trusts, I think a trust would be a good idea, either for even a company. So let's say, for example, you say, I have a house and it has rental income. And this is the rental income that I would like to take care of me in my declining years, to feed me, pay my bills, that sort of thing. You could appoint somebody to hold that income in trust for you, and either a person, or you could incorporate a company with your family members. All right, so 2 or 3 of you, your close people who are close to you, get a company, and then have the company, give the company the responsibility of running your affairs, collecting the rent, ensuring that your bills are paid. And then, it may come at a cost, but then it would help you if you have an employee and then they are supervised by your family members. It sounds complicated, but I think it's doable. And maybe then your family members could check on them. And if you did that, it will not be there. Nobody can say that at the point that you gave, that this trust was created, you had capacity, and that you no longer have capacity, because the trust is not extinguished by that issue of capacity. Now, wills. Let me talk about wills. The time to do your will is when you are still capable. At the point you are incapable, it's too late, and your will be challenged for sure. That will be it will create a challenge to your will if you wrote your will at the point that you are already certified to have an incapacity. Although the case law is interesting in what you said, Posa, if you wrote it during a lucid moment, then then your will stand. But I need to say that a will only takes effect when you've passed on. So as long as you're alive, your will does not take effect. And so even if you have given somebody property under a will, they can't take it until you have passed on. So you have to have passed on for your will to take effect, number one. Number two, you shouldn't be giving your will after. It will be too late. If you are writing your will at the point of incapacity, somebody will just be quietly watching you. If there are devious persons in your family, they'll just be watching it quietly and thinking, once you're gone, they're going to challenge the will, and all they will need to do is to provide evidence that at that point you are already too far gone. So if you're writing your will, the thing to do is to do it early. If whatever you can do if you foresee incapacity, and I say it could be, some of us can foresee, I think. I keep saying that we have mental illness in my family. And I didn't tell my husband this before we got married. I think he heard about it after, but one of my great grandmothers. And so what we've done, one of my great grandmothers is said to have committed suicide, and I think she had a mental health problem. But then, and what we do now is to always check on each other's mental health, remind each other that, our great grandmother. So check on each other with my sisters and my siblings. We are very conscious about the mental. So already it would put us in a place where we need to think that one day there may be decline. What can we do about it, and what should we do about it? And so I would say is to write your will early, review it, maybe every 2, 3, 4, 5 years, depending on how things are going for you, knowing that the decline could be coming. You may have longevity, but your mental decline could be coming. Create these trusts where if I lose it, my property will be held by so and so, and they are supposed to apply it for my benefit, to pay my bills, to pay my debts, to manage, to take care of my dependents. So there are various things to do that you could put in place, But in terms of writing your will, your will will only take effect if you're dead, not if you're incapacitated, number one. And number two, don't wait to write your will when your mind is gone. Do your will early so that it's not going to be, it's not challengeable. Because a devious person in your family would just be watching and saying, well, you go ahead, do the will, but I'm waiting to challenge it on the basis that you are already certified as mentally incapable at the time that you are doing your will. And that's a valid challenge to a will. Were you of sound mind?
Is there something like a verbal will?
Yes, you can do a verbal will, but in Kenya, your verbal will is only valid for 3 months. So if you do a verbal will, you have to die within 3 months for it to be valid. So
Okay.
if you, you'd have to die within 3 months for it to be valid. If you die on the 96th day after you did your verbal will, then that verbal will is not valid. Unless you are going off to war, you're a member of KDF, Kenya Defense Forces, and you're going off to war and then you die in Somalia, then, maybe your will was 6-7 months old. At the point that you are going off to war, you did a will. And then a verbal will cannot invalidate a written will. And we saw that with the DJ. Was it Big Kev? No, there was a Kenyan performer, celebrity, who had a written will, and then he was in hospital, he was very sick, and he's purported to do a verbal will, and there was even a recording, I think either a video or audio recording of that will, and that was invalidated because he already had a written will. An oral will cannot invalidate a written will. So if you have a written will, you have to rewrite it, do what we call a codicil, or do a fresh will in writing. A written will a verbal will will not invalidate a written one.
I pity the lawyer who is trying to defend an oral will anywhere.
I beg your pardon?
I pity the lawyer who is trying to defend an oral will.
Yeah. And somebody did try to defend and say, this is what he said, because the family was putting pressure. This is what he said. It was recorded. It's recorded. But then the court said, no, if it's fine, it's recorded. And he did die within 90 days. He was very sick and he did pass on within 90 days. But because there was a written will, the purported oral will, yeah, so the lawyer had a hard time, but I'm sure they had already advised their client. But
I think it may be useful to return to the subject of trust a little bit. And again, trust is a bad word because it has this dual meaning. We were talking about trust before, the trust between people. And then these weird lawyers take the same word and try to apply it to something that is not about how we feel about each other in terms of confidence of action, but about an artificial legal entity that people who are not lawyers would be hard to figure out the difference between the words. So to understand a trust, one has to understand that the law is okay with fiction. Things that kind of don't really exist otherwise, except that we say they exist. And a trust is a perfect example of us creating a thing out of nothing. We say there is this thing called a trust, and we have bestowed on it magical powers. And one of the magical powers we bestow on it is that, like people, it can own stuff. Who would do that but lawyers? But we've done it and it exists. So we can call something into existence, the trust, and then imbue it with power to hold property and to engage in enterprises apart from the people for whom the trust exists. here's an example, and I'll draw from my own experience. My parents, again, extraordinary planners. They followed the Leah approach, and they established a trust. So my parents, their names were Neville and Sheila Smith. They said, okay, Neville and Sheila exist over here. Now let's take advantage of the legal fiction and create the Neville and Sheila Florida Trust. And then what my parents did, this was probably about 5 or 6 years before my father passed away, they said, okay, we're not going to own anything. The house, the car, the bank accounts, they all now belong to the trust. So there's nothing to pass in a will because we don't own stuff anymore. People want to come after us for whatever they can't because we're poor. We don't own anything. We have zero. The trust, on the other hand, has a whole bunch of stuff. So what happens to the stuff when it goes to this magical entity called the trust? Well, someone needs to be able to control it. And what happens in the law is my parents said, okay, we created the trust. Now we'll create some trustees, people who manage the trust. And guess what? We are the trustees. So we will manage the things in the trust to our benefit. But we'll also make it this way. The moment we either are incapacitated or that we pass on, someone else will become the trustee. Mm-hmm. And my parents, again, with my siblings' agreement, made me the trustee. And that's an enormously powerful thing for avoiding legal processes, because it means when they became incapacitated and then when they passed away, I didn't have to wait for their property to come to anybody, me or anyone else, through a will. They didn't have any property. The trust had the property, and now I was the trustee. And my parents not only planned that, but they also did things like wrote a letter for the bank. If James is arriving at the bank as the trustee, please note that we also had him in the bank documents listed as the surviving trustee. And this is what the checks should look like after we pass. It shouldn't say Neville and Sheila Trust, Neville and Sheila trustees. It should say Neville and Sheila Trust, James trustee. A day later, the bank handed me the new checkbook with my name on it. No court in Florida had to be involved, none of that kind of stuff. Now, here's the thing. As the trustee, when my parents were still alive, when my mother was still alive, or when my mother was still alive, I did not at any time really seek to become the trustee during her incapacitation, because I relied on the power of attorney to act on her behalf with her still as the trustee of the trust. And then the trust converted to a surviving trust with me as the trustee only when she passed away. No wills, no court, none of that kind of process. And critically, no taxes. Because when things pass through a will, oftentimes there are taxes to pay. When my parents passed, there were no taxes to pay because there was no will and there was no passing because they hadn't owned anything, the trust did. So that's one approach. It doesn't work everywhere. And again, the trust, the entity, really relies on trust in the trustees who oversee the trust. That's one approach. It doesn't work for everybody. And then the other big approach is that of a will. And again, I have no disagreement with anything Leah said. I think she went right to it. Don't wait until it's too late to do the will. And the problem with doing the will early, and there is a problem, there's a reason people wait until it's too late. They shouldn't, but there's a good reason they would, because human relationships and interactions are dynamic. The person who is the favorite daughter in 2021 may be the least favorite daughter in 2024. Meanwhile, you've given her 90% of what you have in the will. The people who write wills want to take account of the reality at the time. But if you wait too late, no reality will count, because your will be what it was before, because wills made with undue influence, when you don't have capacity or any of those things, they just don't count. And then we're back to this other thing that just happens way more often than people think it would. You have 4 or 5 siblings, all of whom seem to be getting along just fine. And then there's a will, and it doesn't divide property the way those 4 or 5 people think it should. And suddenly the cracks in the relationships, they all come to life, and people are arguing about what it should be and saying that whatever's in the will shouldn't count. The way the person providing the will can get around all of that is to say, okay, things might change, but I'm not going to wait until there's a question as to my ability to write the will. I'm going to go on the basis of what I know now. I'm going to write the will when no one has any doubt about my lucid mental function. I'm going to get it properly witnessed and preserved. And I'm just going to take my chances that the bad daughter didn't go out and marry some evil person who's corrupted her mind and made her want to do all sorts of evil things to me and other people. She'll get whatever I said she was going to get. And that's just the way it's going to be.
Sorry for the echo, but I'm just wondering, does KRA also come for your will and trust stuff, like the way in the States you can almost go the trust way and the IRS won't be on your back?
We are getting there. It's very interesting. Trusts fascinate me, especially because our law on trusts has been in place, but the way you register them and tax issues around them have been very. The law has not been it's not been enabling, so that the law of trust on the one hand is in place, but then when you try to activate it for your everyday life, then what happens is that you can't. So for example, you can do what James's parents did, but then you have to pay taxes on that, maybe trust company, and our revenue authority has been saying you can't declare nil profits every year. So there's been issues with tax, and so trusts have not quite developed the way we would hope them to be. And then we get a lot of instructions with people who live abroad. If you live in the US, for example, like Posa, you do, and you are aware how trusts run. You have coffee with James, and you have this conversation about the trust that his parents set up, and then you want to do the same for your property in Kenya. And then when you come, it's not as developed in Kenya as it should be abroad, as it is abroad. But then it's growing. It's very interesting. There's pressure for it to develop. And just recently, there have been amendments to our trust law that were just 2 weeks ago. The president assented to an amendment to the Trustees Perpetual Succession Amendment Act. So our law is actually living, breathing, morphing as we speak. And there are actually tax benefits for family trusts that are going to come in, where the law will be telling KRA, step aside a little bit, hands off on family trusts. And so our law is developing to be the way it is in other places. It's taken time, but with lessons from other places, we are getting there. And I suspect I didn't answer your question. Yeah, but what you asked about KRA, about the taxes.
The tax issue,
yeah. Right now there is movement towards protecting families, and just the way James said about his parents' trust, it's the same in Kenya. If exactly the way he put it, if you put your property in a trust, then it doesn't become the subject of a will. And so it would be there would be no action once the person is gone. It's not the subject of probate or of a probate process in court. The trust continues to run as you set it up, whether it is passing on or whether it is incapacity that has happened to you. So very interesting developments in our law, and to just I'm hoping that in the next few years it will iron out the kinks in the law, because the Trustees Perpetual Succession Act has been there, the law that allows you to put property in the trust, but then registering, I think I've seen 2 or 3 in my 18 years of practice go through. And even the people who had theirs registered were highly connected, so that a call came from the highest office of the land requiring that the registration happen. And I'm saying so with a bit of shyness, because I can see some of my colleagues on the call who are senior lawyers. They might have they might have had some better experience, some better experience with that. I can see Buta Siganga. I want to recognize you as my senior. We lawyers are like this. James, I don't know if lawyers are like this in your country, but when as your senior walks into the room, you have to recognize their presence. So I want to recognize the presence of Buta Siganga. He might have something to say about trusts. Mercy, I had seen your sister earlier. I don't know if she's still on the call. Pauline Gidogo, also my senior. She might have something to say about it. But the experience has been, and I recognize your presence, Pauline. My experience has been that it's been difficult to trusts have been, there has been a regime in place, but it's been difficult for families to actually tap into that instrument, that creature, as James calls it, that's available in the law, because there were no tax benefits. And even just registering it in the first place required you to be connected to the highest offices. And maybe my senior colleagues have had better experiences. But in my 18 years of practice, I've just seen 2 go through.
So I should interject this, and it speaks, it almost brings tears to me to think about the brilliance of my parents, who would have said to me, and maybe did at times, James, you may be the member of the bar, but you need to pay attention to us to learn how to practice law. They were school teachers. They thought very seriously about exactly what Leia's talking about now. Even in the United States, where trusts have existed for a long time, trusts of this type, which can be used to, among other things, avoid taxes, and the whole probate process, which is how a will comes to be carried through. State governments don't like them. And one of the main reasons they don't like them is that they can be vehicles for avoiding tax. And there was some uncertainty in Florida law when my parents created the trust. It was amazing to me when I was going through the papers, which my parents had described, and I understood what they wanted. I found a letter in a file that had their will. And the note said, James, the status of trusts and whether they really survive may be in question at the time you become the trustee. If it happens that the state of Florida does not recognize the trust, unregisters it, you may need a will. Here's a will.
Oh, wow.
I nearly fell out of my chair.
Oh, wow. That's amazing.
It's amazing. But it's a great strategy, precisely because the law of trust is still developing and it's unclear whether at the time you need it to work, it will work. It's good to have the backup plan in place of a fully witnessed, well-written will, which won't operate if the trust owns the property because the people don't. But if the trust doesn't own the property because it's been invalidated, ownership reverts to the people, and then you need a will. I don't know where my parents came from. That was just brilliant.
They came from Trinidad.
They did.
So I'm just, okay, this is me and my, I don't know. Let me ask you, if there's a clash, like we who's traveled both sides of the world, if there's a clash between the two laws, is there like an arbitrator? Like if I'm registering property with my American mind, but in Kenya, and it clashes with my, with the other side, is there like a Hague sort of, that arbitrates these two sides and makes me not suffer?
The rule is, okay, so if it's real property or what we call immovable property, so if it's a house, if it's land, the law of where you are will take over. So if it's your property in, I don't know, where's your dream property, Posa?
In my village in Luanda Dudi, not even Kitale, Luanda Dudi.
my dream is in Kitale, and I don't have relatives in Kitale. But my dream land is in Kitale. So if you have property in Luanda, what did you call it?
Luanda Dudi.
Luanda Dudi.
Yes.
So it's the law of Kenya that will apply, and then your property in the US, the property in the US will be determined as per US law. But then anything else, shares, movables, shares, your jewelry, I suspect your Bitcoin, if you have it, those things that are movable are determined by where you are, where you're domiciled.
Okay.
Yeah. So where you the country that you made your home. That will be the one that will determine. So if you have shares in Kenya, they will be distributed according to, if there's a conflict, there will be of course your will takes precedent, but if there's a conflict, then and that part of your will, for example, is invalid, or your will is not considered valid, the distribution will be based on where did you make home. So somebody will come to argue about your KQ shares, which are good shares, and your KQ shares in the court in the US, and where you stayed, where you passed on, wherever you made your home. It won't matter that they are KQ shares. They should be distributed according to the law of the place that you made your home.
Okay. Leah, I think you'll reach out to Wakesha in case you want to share your contacts. And Kafoi is asking, can you register an LLC in the US and put property in Kenya in it?
You'll have a hard time. If you have maintained your Kenyan citizenship, you could. But you see, this is a foreign company. So, we have laws on who owns foreign ownership of land. And so it's interesting because the company is foreign, but because yeah, if you're a foreign company, you can own property that is leasehold property, which is property in Nairobi, or almost everything is leasehold. Kitale, almost everything is leasehold. There are places where almost all the property is leasehold, and you can own, the foreign company can own for leasehold property. But if it's freehold property, the property that we have up country, the agricultural properties that are freehold, you won't be able to own it because you're a foreign company. So I would suggest that you register a Kenyan company to own it. But if it's a leasehold, if it's a flat in Kileleshwa, or if it's land in Nairobi, or land, and most municipalities, land is becoming leasehold in places which are urban. And that you can own even if it's a US company, that's not a problem. But if it's land up country, for example, that is freehold land, because of the requirements of registration of ownership of foreigners owning freehold land in Kenya, provided under the Constitution.
And leasehold just means it's owned by the government. They're just giving you for a time, right? And
yeah,
freehold is owned by your
99 years.
Okay.
Yeah, it's 99. You have it for 99 years. You will be able to renew your children or whoever you sell to. After 99 years, they have to apply to the government for it to be renewed, the leasehold to be renewed to them. And freehold is where, that's not an issue. It's the land is yours. But a lot of land converts also to leasehold. As soon as you want to build something and you want approvals, the county government says, we are going to convert it to a leasehold in exchange for us giving you permission to build your skyscraper.
Okay, because we need to, in the next 30 minutes, we have no choice but to shut this down. I just want, we're going to have a conversation on death, you know me, next year. But I'm just wondering, in terms of preparation for eventualities, includes preparation for death. I know here you can sign DNR, as in do not resuscitate orders and all that stuff. How do we avoid the Terry Shivo case? I think everyone in the world knew that case. And James, this is your question. Leah, I don't know how far we are in DNR in Kenya, but let's start with.
I'm not sure I know the Terry Shivo. You have to tell. And
James,
I don't know where I was. I don't know where I was when it was happening.
How on earth did you know that Terry Shivo?
I don't know, sorry. I don't
okay,
bear
James, do you want to tell us the Terry Shivo case and then the planning for death, and can people refuse to cremate me if I want everyone on this call, I want to be cremated. My husband is hearing. And yeah, I belong to that community that doesn't like cremation. But yeah, let's go. James, go ahead.
Sure. So maybe the another term to invoke here and explain is the living will, which again, may be bad terminology because wills are supposed to be about when people pass away, what happens to the property, and a living will is not about that at all, has nothing to do with property. It's about treatment for a person who still is alive. And the case POSA refers to involves an individual who, is it going too far to say she was essentially dead? That
it's not going too far, she was dead.
Her body was being kept minimally operable by way of machines. And there was a fight over whether that should continue, how much invasive intervention by machines and medical persons should be allowed so that her body functioned when she was essentially gone. And she had not provided, as is true of many people, a living will with instructions as to at what point those kinds of measures no longer should be taken to keep her body functioning. So there was a fight over those things between hospital, state, family, and it resulted in her being in that condition for a very long time. I think even more than a year, years?
It was years. It was more than 10 years, I think. It was ridiculous.
How might one prevent that? Well, again, when a person has full capacity, tell people, and not merely tell people, but write it down and have it acknowledged. Here are my instructions. At such and such a point, no longer take steps to keep my body alive or to keep me in the pain that may be associated with being alive and treated still. And one specific example of where instructions may be given is what Posa referred to, the DNR, do not resuscitate. An instruction to medical people, which they're bound to follow, or should follow. The person has said, if I, for example, go into cardiac arrest, don't take the measures necessary to keep me alive, allow me to pass away. Again, I have deep personal experience with these things. My parents' instructions, they had living wills, they had them recorded. They were even uploaded at the hospitals where they received treatment in their final years with their final medical conditions. And they left some wiggle room, some variation as to, because these things are not often easy. You don't read clear, definitive points about you're at this stage now, you're at this stage, so make these decisions. It's rarely that plain. But they generally specified when they no longer wanted intervention in their living wills. And at a point, my mother signed a do not resuscitate order. She had sufficient capacity to do that. And sadly, the order, the request, the do not resuscitate request was posted in 2 places. It was posted in the house so that if medical personnel came there and needed to make a decision about whether to resuscitate, they knew the instruction, and it also went up in the hospital room whenever she was under care. And again, a specific example illustrates some of the things that come about in these situations. So my mother passed away largely from renal failure. She had been on dialysis for the better part of 3 years when she passed away. But prior to that, about 3 or 4 years prior to that, she had another ailment. As a teenager, she had rheumatic fever, which damages the heart. So she had a bad heart valve, and in her early 80s, she had the heart valve replaced. Now, replacing a heart valve is a difficult thing at any time. It's kind of miracle surgery. Doing it for an 81-year-old person is especially challenging. And one of the things that had to happen in the surgery to access the heart and do the valve replacement, this was an aortic valve, so we're talking a biggie. They had to cut her sternum and then stitch it back together. And of course, when you're that age, the sternum grows back together slowly, and there's great question as to its overall strength, which meant if she was being resuscitated because of cardiac arrest, she would have people pressing down on a sternum that had been cut and stitched back together. And everyone, my mother included, saw that as an absolute nightmare because the bone could give way, and then don't even want to describe how ugly that would be. So getting to a do not resuscitate order was a fairly straightforward thing. And that was expressed both in that request and also in the living will. This goes back to fundamental things we're describing: planning, open, straightforward discussion and trust, and not denying the reality. Let's not pretend that we're talking about a 30-year-old sternum. We're talking about, and for those of you who might be less familiar, the sternum is that bone that, at the upper part of the rib cage that provides structural integrity to the rib cage. That is different on an 81-year-old who's had it cut by a saw and a 30-year-old who has never had it cut, which suggests a different kind of approach when resuscitation might be needed. Again, living will, record it, have a discussion, know what the treatment options are and which ones are not viable, so that the person who is, and you can't ask them when they need resuscitation. You have to have asked them before, and you need to have it written somewhere.
Let me comment on the Kenyan situation, because the law and the courts, at least as far as I know, have not addressed this issue of living will or DNRs, or do not resuscitate. And but then this is a case which is of the law of society going ahead of the law. So I know that hospitals actually have documentation that allows you to make a do not resuscitate order, or at least, I don't know if you want to call it order, but yeah, it's an order where you are giving them instructions not to resuscitate. They actually have forms that I guess they have picked up from other jurisdictions, because our law has not got there. And I don't think our courts, as far as I know, have addressed this issue. And so the society has gone ahead of the law because of needs, and so hospitals do. I can see a comment from Anne Ngugi saying that at Nairobi Hospice in Kenya, we encourage patients and families to make advance directives, including living will and power of attorney. So medical power of attorney saying who should make your decision in case you go into a coma, or you can no longer communicate, and you do that in advance. So the medical community has gone ahead of the law and put those things in place. And so I know that they are in place, and I know that hospitals have that in place, even as Anne Ngugi has indicated from the hospice perspective. What I do as a lawyer when I do your will is I have this discussion with you, and because your will only take effect when you've passed on, what I have done in my practice is to do a letter to your executors after you do the will. It doesn't say what is in your will. It doesn't say the contents of the will, but it just says you have written a will. You have appointed, and I have appointed you. We write to your executors and say, so-and-so has written a will. It is dated this date. And we have appointed the person writing the will has appointed you as the executor. And then the following are their wishes. Are their end of time wishes. And so we say they wish to not be resuscitated, they wish to be buried in this and that place, because we open wills way after the person has died. And then they wanted to post, maybe you wanted to be cremated, it's too late. You are already buried in.
I shall haunt you.
You see, so when we open your will 2 years later, you wanted to be cremated. So what we do is when we do your will, we will write to your executor and inform them that there is a will, because sometimes somebody dies and nobody knows if there is a will. We'll write to the executor and tell them there is a will, and these are your end of life wishes, and that you are appointing the person to say to the family that this was her end of life, and this is the document from the lawyer, and the person had given the lawyer instructions instructions that this is what they want. So this is a case of the society and the needs and the needs of people going ahead of the law. And I'm sure the law will catch up eventually.
Okay. And I think the medical board will catch up. I think has been wishing to do this for a while. So
and it's very kind. I think it's kind to your family members. Yeah, because then they're not in a, in a limbo. There is less of dispute.
Yeah.
This person saying this and this person saying that. James, I think your parents were so wise.
Yes.
I wish they had written books. At least you need to write a book about them, because it's so kind to family members to do this, so that this is in place, and then you avoid disputes, you avoid discord.
And hospital bills.
Yes, and allow people to focus on the key thing at the end of your life.
They were extraordinary.
Absolutely.
I think we will wind this down. It's been a great discussion. Does any other lawyer on the, because we have to tip the hat to our seniors, right? The muter, I can see you've unmuted. Do you want to
Yes.
comment? Okay, go ahead.
All right. Thank you, and hello everybody. Thanks for having this. I came in a bit late, and I'm sure I missed quite a bit. It's a good initiative. I think it's something that's very live in Kenya. Maybe just to start off with what Leah said about the durable powers of attorney and the courts, because I'm not aware of anybody who's prepared one, but I'm aware of a couple of cases where courts have appointed guardians over people who had some disability. And so I'm just thinking, if you prepared a durable power of attorney, it would be the courts would uphold that. And earlier this year, I actually prepared one for a client. It was for finances, because he couldn't move around very much. So we did that. He didn't feel ready to do the one for health, and so that was really okay. The discussion was good. I remember I've read somewhere that 80% of all medical expenses are spent on people in the last 12 months of their lives. For Kenya, that's a big thing. And what we've been talking about, giving directions on what should happen. If you've got to the point where a doctor says there's really nothing more that can be done. So I think it's something we need to think about. Wills are good, but what happens before? When you talk to prosecutors, they tell you a lot about family members who transfer property even while the person is still alive. So it's something that needs to be thought about, and what can be done to help those our elders who are in decline and who are being taken advantage of because either their children are living away or there's somebody who's been brought in and is just doing damage. And then finally, what I'll just say about wills, I've spoken to many people about writing wills. I think part of the challenge we have in Kenya, especially among the men, is that they run very complicated family relationships. They've got a formal wife and there's many other, sometimes they have mistresses or children outside. And so they don't really want to make the decision that this is what I'm leaving to such and such, because either they'll leave somebody out who will then challenge it, or they'll include somebody and then the wives will know what's going on. So I think it's something that as Kenyan lawyers, I think Leah and all the other lawyers present, we need to think about how can we help people like that who, and especially with the recent changes in the law of succession, so that they can feel comfortable leaving it. Because you can see, if you have children that you haven't declared to your other family members, when you die and it's being dealt with interstate, there's still chaos. So either way, there's a problem. So it would be better if you put it down and people then know that you have property, that you have this dependence and all. And finally, just an acknowledgement to Leah. I've known Leah for many years since she was a young advocate, and she's always been thorough in all that she does. So it's really been nice listening to her and just thinking, well, this is a good initiative, and I hope all of us benefit from it. Thank you. My name is Yuta Siganga. I practice in Nairobi.
Oh, thank you. I don't know where I'm echoing, but thank you, Buta. Thank you. Who was the other lawyer over here now? Okay. What I'll do about the recording is I'll share it with Leah, and I'm gonna share it with Bugo, who has to go, who had to leave, and then they'll share it on Facebook, and then I think then they can share it out. Yeah, just say, go ahead. Sorry.
Allow me to say one last thing. Sorry, Posa, to interrupt. About if you are in a situation where already your like, for example, your parent has declined significantly and she's not capable, or he is not capable of doing a will, a good thing to do while you could do while they're still alive, to avoid fights after they are gone, because once they are gone, the property, then it looks like it's lying on the road and anybody feels entitled to it, is you could explore the idea of doing a family settlement agreement. If you think they can't do a will, the will could be challenged on the basis of their mental capacity, but they have seasons of lucidity and they are lucid enough to be engaged in this discussion, but not sufficient to reach the level of a will. And while people are still behaving themselves because their mother is around or that their father is around, you could explore having a family settlement agreement where everybody sits and you acknowledge that this is not our property, our parents or our parent is still alive, but why don't we talk about what's going to happen when they are gone? And everybody agrees and everybody signs. So that when they are gone, because it's too late for them to write a will that will stand up, then there will be that discussion that was had when people were still sober, while people were still, had the parent in the room to respect, and that can be taken into account. That's something to consider if it's too late for your parent to write the will because they are so incapacitated. If everybody could sit around a table, discuss, agree, and sign on the dotted line under a family settlement agreement, which means afterwards, when you go to court, you already have an agreement in place that's been thought through, and it could actually reduce acrimony, reduce the adversarial state that comes up when people are fighting for the very last thing. Because if somebody objects, they will have been a party to that meeting where they agreed while mom was still alive or when dad was still alive. That's something that families could consider if you're at a place where it looks like it might be too late and you're just waiting for impending doom or impending fights in court.
Okay.
Posa, if I may mention as we conclude here, my parents one more time to touch on something Buta mentioned and also Leah mentioned. One advantage to my parents' situation was that they led a certain kind of simple life. My parents, when my father passed away, had been married for 49 and a half years. And she was his one wife. And we're fairly sure there were no other children anywhere. Certainly none stepped forward. So we knew which people were in the discussion, which meant the people who could both agree and disagree. And essentially my parents had in mind what Leah is describing, but they did it in a somewhat unorthodox way. They wanted family settlement, an accord between the family members that we reached on our own and therefore needed no court. And they left me as the trustee and with substantial discretion to the distribution of the assets. But they left this also. They said, James, one day you will have to account to us for your actions as the trustee. So make it that when you wrap up the trust, not only your brother and your sister, but other people we have mentioned to you and put in the instructions generally, that none of them is dissatisfied. If there's going to be anybody dissatisfied with the distribution, let it be you. And confident that someday they will call me to account. I don't want to get in trouble. So that's how, and I think they knew that I would view myself as accountable. It's good if whoever is seeing to the resolution aims, again, exactly what Leah is saying, at accord between all the people with interests impacted by the passing of the people or the person.
So Nairobians, you've heard this person sharing needs to stop. Thank you very much, James, Leah, and I will go on the side. And thank you, Buta, for your contribution. Thank you for joining us. I'm gonna send out the recording. In January, we are gonna, I'm trying to have different conversations from what we hear, especially in the Kenyan and the US media. So it's a different conversations we deserve to have but don't have. So in January, we're gonna tackle cancer, parenting, and something else, menopause. So you can join us. However you got this link, you shall get it, and just join us. Thank you. And from James and I, because we are the Adventists over here, happy Sabbath. Kwaherini. You can join us on our Sabbath School Zoom. I can send out the link.
And Leah, it's been fabulous learning from you. Thank you so much.
Yeah. I've enjoyed the conversation very much. And your parents, you have to write a book about them. And thanks. Let's keep in touch, because I think your law is a little bit ahead and we're trying to catch up. So it will be nice. There will be so much to learn there. Thank you so much.
Thank you.
Asanteni, kwaherini.
Thank you.
Okay, bye-bye.